Yes, Vijay sir.
Yes, thank you. Good evening, everyone. Respected distinguished resource persons of the day, Professor Dasrath N. Sir, retired professor, Bangalore University, Bangalore. Respected principal, sir, my dear esteemed colleagues, and dear participants. I am Dr. Vijay A. Assistant Professor, Vivekananda College of Law, Bangalore, and Coordinator Faculty Development Program. It is my privilege to welcome you all to the final day of Faculty Development Program on New Labor Codes. Today we have with us a distinguished resource person, Dr. Dasrath N., retired professor, Bangalore University, Bangalore. It is my honor to present a brief profile of our esteemed resource person of the day. Sir was born on 25th 1964 at Raichur, Karnataka. Professor N. Dasrath is son of lower middle class family of late T. Narsimulu and Srimati late Chennamma. Completed pre-university education in Raichur and thereafter came to Bangalore in 1985 to do engineering in RV College of Engineering, Bangalore. Due to decreasing eyesight, discontinued engineering course and joined first batch of 5 years BLLB course 1986 in the University College, Bangalore, University Bangalore. Completed LLB in 1991 and thereafter completed LLM in 1993 from the same college. Started teaching career from 1994 and served as a principal Indira Priyadarshini Law College, Bangalore from 1995 to 1998. Served as a full-time law teacher in BMS Law College from 1998 to 2003. Joined University Law College as a permanent teacher in 2003 and is permanently working as a professor of law and principal of University Law College, Bangalore and Department of Studies in Law, Bangalore University, Bangalore. Completed PhD from a prestigious Indian Law Institute deemed Central University, New Delhi, for which Chief Justice of Supreme Court of India is the Chancellor, received a PhD convocation from then Chief Justice of India, Justice K.G. Balakrishnan in 2010 at Vignan Bhavan, New Delhi, by becoming the first blind person in India to obtain PhD degree in the law. Received National Award as the Best Employee from the President of India, Dr. Pranab Mukherjee. The award was instituted by Ministry of Social Justice and Empowerment, Government of India. Received the said award on 3rd December 2014 at Vignan Bhavan, New Delhi. Received Gautam Buddha Dr. B.R. Ambedkar Bharatiya Dalita Sahitya National Award at New Delhi in 2014. Received Dr. Babu Jaganjeevan Ram Best Social Workers Award from Raichur District Administration. Visited Sri Lanka, Thailand for presenting paper at international seminars. Presented a paper at national seminar also. Till now, 9 research scholars are awarded PhD degree under the guidance of Professor Dr. N. Dasrath. Professor Dr. N. Dasrath is the author of 3 books, namely Vision of Social Justice, Reasonable Accommodation at Workplace for Person with Disability, Untouchability and the Law, Western Jurisprudence and its Relevance to India, the Bharat. Became the first visually challenged blind person in South India to serve as the chairperson of the University Law College and Department of Studies in Law, Bangalore University, Bangalore, and also the first visually challenged person to adorn the position of Dean Faculty of Law in India. Professor N. Dasarath served as a member of Board of Studies in different universities, member of Board of Examiners for adjudicating PhD thesis, and also served as an ex officio member of Karnataka State Law Commission. Recently received a Dignity of Community Award for excellence in academic field for becoming the Dean Faculty of Law. The said award was instituted by National Federation for the Blind on 4th January 2021 in the presence of Director, Vice Chancellor of National Law School of India University, Bangalore, Senior Film Actor Sri Doddana and the Director of the Person with Disability and Senior Citizens Government of Karnataka. So with this brief introduction, Sir has accepted our invitation and agreed to deliver a special lecture on interplay between ease of doing business and balancing workers' rights in the light of Code on Industrial Relations and Analysis. So I, on behalf of the Janata Education Societies, Vivekananda College of Law, and on behalf of the participants, a warm welcome on this occasion, sir.
Thank you so much, Mr. Vijay.
Yes, sir. Thank you, sir.
Coordinator of this.
And also, I take this opportunity to welcome our beloved principal, Dr. K.B. Kempagoda, sir, on this occasion. And also, I welcome my dear colleagues and dear participant on this occasion Over to you, sir.
Thank you so much
Thank
for
you, sir.
your brief and nice introduction about me. Uh, Firstly, at the outset, I thank the Janata Education Society and the Vivekananda College of Law, Bangalore, and most importantly, the head of the institution, the principal, Professor Kempagodaji, his team of teachers, a very dedicated, learned team of teachers he has, and Mr. Vijay, the coordinator of this faculty development program, the participant across India, dear ladies and gentlemen. Today I have chosen the topic interplay between ease of doing business and balancing workers' rights and analysis. Friends, I use the word analysis for the obvious reason. Instead of that, I would have used the word critical analysis. I don't want to look at the code of industrial relations in a very critical way, but like to put my ideas before you and take ideas from your side also to see how best a very fair business environment is created in our country. Side by side, how best and the just balance of rights of workers are also achieved by the Code of International Relations. Friends, 98% of the companies, be it they run industries or factories, they started with an object to run their ventures in a very progressive way, which is useful for them, for the workers, and the nation at large. At the same time, most of the workers accept the employment with an object of contributing their work, be it be in whatever manner, with whatever skill they possess, but they do not join the companies, the factories, or industries to misbehave or to go on strike or to disturb the vehicle of production, distribution, and supply of goods and services. In this way, I look at broadly the industrial relations. The area of industrial relations is not to make money or not to waste capital, but to progress on either sides with very good, peaceful, harmonious, cordial, and friendly relations. Money makes many things, but not all the things. So therefore, industrial relations in any country are very crucial for the growth as well as the progress of the country. Without wasting time, I'll come back to my topic. I have 10 topics for you to, subtopics for you to deliver my lecture, and I would like to seek your ideas, observations, if any, to put the lecture in a very interactive and discussion manner. Firstly, I will take up very important changes that have been introduced by the Code on Industrial Relations for doing ease of business as well as for balancing workers' rights. Firstly, I'll take up the word employee and worker, which are defined under Section 2, respectively, the Code on IR. May I make a hypothetical statement stating that employees are not workers, but workers are employees and workmen. However, employees can be workmen provided they are decided on the basis of the nature of functions they discharge
ಯಾಕಂದ್ರೆ ನಮಗೆ
without
ವೆಸ್ಟ್ ಇಂದ್ರಲ್ಲೇ
considering
108 ಪ್ರಾಬ್ಲಮ್ ಆಗಿದ್ದು. ಈಸ್ಟ್ ಸೌತ್ ಇದ್ರಲ್ಲಿ ನಮಗೆ ಒಳ್ಳೇದೇ ಆಗಿದೆ ಆಕ್ಚುಲಿ.
without considering the designation as well as the salary riders. So therefore, if you please carefully observe these two definitions, the worker, the employee and the workers, you can come to a conclusion that the term employee is defined for the first time in the Code on IR. There was no such a definition of employee under the ID Act 1947. The term workman was already there and has been defined. But what is the difference between these two terms? Firstly, the term employee is more broader than when compared to the term workman. Secondly, a very remarkable distinction that could be observed is that the word semi-skilled is used in defining the term employee, whereas the word semi-skilled is not used while defining the term workman. The third difference is that there is no any salary rider for defining the term employee, whereas there is a salary rider of 18,000 rupees for the supervisory staff, and if the salary exceeds 18,000, then they will not be considered as supervisors. So these are the three broad distinctions that I could find. But then may I know from you, dear learned teachers, why the word employee for the first time has been defined under the code. May I have your learned response? Why the term employee has been defined for the first time in the code? What may be the reason? I tell you the hint also. The Industrial Relations Code uses the term worker everywhere for ensuring protection and benefits. But then, what is the object of defining the term employee in the newly enacted IR code? If you just without wasting time, if I can have your learned response, otherwise I'll go ahead with the answer, please. Am I audible to you?
Yes, sir, you are audible, sir.
Yes, sir, you are audible.
So, just I think we are not taking the aid of any chat GPT or like that. Let us be natural, okay? So, may I tell the answer?
Yes, sir, please.
Thank you, thank you. I'm so great of you. See, the last difference which I could find out between the term employee and the word workman is that in the new IR code, while defining the term worker, they have added two set of employees, that is the working journalist and newspaper employees conditions of service act is covered under the definition of the word workman, and followed by this the sales promotion employees conditions of service and employment act is also covered. Probably for this reason the lawmakers might have defined the term employee for the first time in the IR code. So, to further make it a little clear, I will demonstrate the difference with the help of a decision, very recently delivered decision that arose between Srinivas Godial versus the Airtel 2025 decision decided by the Supreme Court, wherein the question was to be determined whether a frontline manager is an employee or a worker. Now, whenever we come across to decide these type of questions, then we have to look at the facts. What is the nature of work this frontline manager performs? The points that could be taken for consideration are whether the frontline manager has some power and authority to sanction leave. If any other workers or employees are working under him, and if he has got the authority to sanction leave, if he has got the authority to issue charge sheet and initiate disciplinary proceedings. If the answer is no, then the frontline manager is a work. Otherwise, he will fall under the category of employee. So therefore, friends, while determining the distinction between worker and employee, what is most important is the nature of the functions which one performs. Designation is irrelevant, salary rider is irrelevant for us. So therefore, I can say that a very good lucrative IT employee drawing 1.5 lakh rupees may fall under the category of worker. A pilot who navigates the aeroplane may come under the definition of worker. But at the same time, in IT sector, A team leader may not come within the definition of worker, because he has some nature of functions to supervise, to 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 take note of whether they respond to the work allotted they have done or not. So therefore, the team leader cannot be considered as a worker. So in this way, I like to conclude the distinction between the term employee and worker. But one more important observation which I have made before concluding is that they have used the word person while defining the word workman and employee. Why they have used the word person? They were they have either used the word employee or workman. Workman means any person doing skilled, unskilled. Employee means any person doing skilled, semi-skilled, unskilled. Why they use the word person? Dear ladies and gentlemen, a very interesting question arose. Of course, you are all aware. In Dimakuchi Tea Estate versus the management of Dimakuchi Tea Estate, wherein the Supreme Court had to consider whether a doctor who has been employed by the management of the Dimakuchi Tea Estate is a workman or not. Because the workman was dismissed by the management for the obvious reason that he was very near and dear to the workers. He was very cordial, very friendly to the workers while discharging his duties as a doctor. So the doctor tells the workers to call a strike, they were ready to call that. So dear was the doctor was appointed by the management of Dimakuchi Tea Estate. So they wanted to teach them and they did it. They got succeeded also, because the matter went from the labor court up to Supreme Court, and where the Supreme Court had to decide whether a doctor is a workman or not. The Honorable Supreme Court decided doctor is not a workman. So these type of questions will arise in the days to come. The dispute has not come to an end by merely defining the term workman under the newly enacted IR code. This is my analysis. Now coming to the second conceptual analysis, that is upon collective bargaining and trade union law, that is used under, that is reflected in different provisions of the IR code. Friends, our trade union movement in our country is a very peculiar one, for the obvious reason that our trade union movements commenced with the independence of our country movement, independence of India movement. By the by, the trade union movement also continued. Many erudite labor leaders, Joshi, Lokande, so many leaders did participate in the freedom movement by organizing workers at different levels of different categories to support the independent movement launched by our freedom fighters led by Mahatma Gandhi and many other freedom fighters. So this is a very peculiar point that could be observed in relation to our trade union movement. And you can find that we got independence, but then we are till today following a colonial law which was enacted in 1926, the Trade Union Act 1926. And we are in 2026. Are we in a festive mood to celebrate the centenary celebration of the Trade Union Act 1926? Instead of celebrating, we have repealed the colonial legislation 2002, 1926, and we have amalgamated or summed up into a newly enacted Code on Industrial Relations. So whenever I speak about trade unions, it comes to my mind the resolution of the French, the declaration of the French Revolution, 1789, which stated all are born free with equal rights and freedoms. So all are born free with equal rights and freedom. Our Constitution of India confirms the freedom of association to form unions, and now cooperative societies is also added. So constitutionally we are guaranteed to form unions. But then it's a matter of great introspection to see how the trade unions were at the time of independence, what happened to them after 1991 when we adopted the new economic policy. They said that led to contractualization, casualization, and sometimes pauperization of workforce. And what is the present position? If you look at these three different stages, I feel that, and I endorse what Pali Nariman, a great jurist, said, the very first ignorance is the very first stage of abuse of freedom. Ignorance is the very first stage of the abuse of freedom. The next stage of freedom, the next stage is the neglect of freedom. So wherever we are ignorant, there is an abuse of freedom. And wherever we are neglect in achieving the freedom, we lose our freedoms. So I feel that we are in a very silent, non-hesitating democracy for generating any interesting jurisprudence from the side of the trade union in our country. Student strikes are reduced to considerable level. Trade union strikes are very rare. Strikes at the national level are also not frequent. But then I will give you a very glaring example which we received the world attention about our unions and associations. The first of that type is when the garment workers in Bangalore, women garment workers in Bangalore, went on strike, apprehending that their provident fund will not be ensured to them in the near future. You know, the garment workers, women workers, organized themselves. It was a leaderless movement. It's a leaderless movement and was not led by any trade union. And no trade union till today will take the claim that we organized the garments workers women's movement for pressurizing the government of India to not to discontinue with Provident Fund. Of course, there were certain uh, miscommunications, but then still the movement was launched, and Bangalore is a place which gets very fast and quick attention throughout the world. So therefore, a leaderless, a trade unionless movement which I observed during my period is the women workers garment movement. Followed by that, the farmers movement for demanding MSP, a minimum support price for their produced, and they were on strike for more or less 1 year in chilling cold, rain and hot summer, but they succeeded in getting the 3 farm laws withdrawn by the parliament. You know how many rupees they spent on 1 second for a debate in the parliament? Cannot imagine. So that is the strength of the trade unions. But then, to put it overall, I cannot say convincingly that the trade union movement is doing well in our country in the recent past. In this regard, Dr. Ambedkar long ago said that our trade unions have a desire to exist but not to live. They have desire to exist but not to live for a long time. Therefore, the sad affairs of the Indian trade union is just like a sinking, union in a pool. So long back he had observed, and his observation has come true now. So with this brief background of the trade union movement, I'll come back to my presentation to convince you how the concept of collective bargaining and the trade union provisions are connected, and how do they interplay for doing ease of business and for balancing the rights of the workers at the same time. Friends, interestingly, if we look at the definition of the word settlement, I think under section 2 L of the IR code. So settlement means a settlement arrived in course of conciliation, and a settlement otherwise arrived in course of arrived with a agreement between the workers and the management, signed by the parties, and the copy of the same is sent to the appropriate government and the conciliation officer. So it stipulates two types of settlement: settlement arrived in course of conciliation, and settlement arrived otherwise than in course of conciliation. So the definition does not use the word collective bargaining at all. Throughout the IR code, you cannot find the word collective bargaining in any of the provisions. Any of the provisions. But then, I was very careful in looking at where could I found this word collective bargaining. Why they are not bringing into focus this word again and again in different provisions of the Act. While defining strike, they would have used the word collective bargaining, and they would have added this also as one of the most method for investigation and settlement of industrial disputes. They have not added this as a forum. But dear learned teachers, I could find this word in the second schedule of the AR code. It was earlier fifth schedule in the old Act. Second schedule of the AR code. The word collective bargaining is used in the first line itself, where the unfair labor practices practiced by the employers. So the employer should not discourage collective bargaining. They have to promote it, and they have to settle the disputes whenever the strikes are called. So there, in the schedule of the Act, which is also the part of the Act, there is no doubt about it. In the schedule, the word collective bargaining appears. It will, barring this, the word will not appear anywhere in the sections that are spread over in the IR code. So collective bargaining is a wonderful method of investigating and settlement of disputes. This will enable industrial democracy and will help us to generate industrial jurisprudence through industrial democracy. Do you think that in our own law college, sometimes it will be very difficult to meet our own principal and talk to face? We sometimes feel fear to meet. I was feeling a little bit fearful when I wanted to meet my own principal, my guru, Professor V.B. Kutin. I had to just ask the peon, Yermartale Sahib, what the sir is doing inside. Can I go or not? How is his mood? Imagine, very democratic way, the unions and the management represented by the unions represented by the workers sit across the table and negotiate hours and hours for resolving a dispute. So what a beautiful industrial democracy in industrial relations. And what a beautiful way we can generate industrial jurisprudence by entering into collective agreements, which could be enforced for the convenient time and period we wish to have. So, but for this, we have some provisions to promote collective bargaining in the newly enacted IR code, in the provisions relating to trade union, wherein the IR code provides for a recognized trade union. If at all, 51% of the workers support a single trade union which is in place in any industry, that sole single registered union will be considered for the purpose of collective bargaining. Where such a sole union is not possible, then there is a provision for negotiating council from where in which from each union 20% 20% of the workforce from each union will be counted as one worker. If there are 100 workers in a union, 20% of each means 5 workers. Like that, we can choose from as many number of unions which are there in any industry, and they could form a negotiating council and may decide, uh, negotiate the disputes and resolve amicably with the management. So these are the very interesting changes which have been introduced under the IR code. Then coming to the third conceptual analysis for doing ease of business and for balancing human rights. So collective bargaining to some extent under the existing trade union in the long run to come, because we are in a period of transition. We don't know how the code is going to work, and how it is going to bring a very harmonious industrial relation, promoting ease of business and balancing workers' rights. But then I am of the belief that the collective bargaining could be promoted to some extent greater than what it was under the erstwhile Industrial Dispute Act 1947. Now, the third conceptual analysis which I would like to take up is the standing orders. So these standing orders, again, the threshold is 300 workers. Wherever in any industry, establishment, undertaking, there are 300 or more workers, the standing orders are to be there. Please bear in mind, dear learned teachers, friends, that the new IR code has a wonderful provisions for having a very good standing orders, for the reason that there are 3 model standing orders which have been provided by rules under the IR code. One standing order for manufacturing sector, one set of standing orders for service sectors, one set of standing orders for IT sectors. So if at all, if an industry want to adopt this model standing order prepared by the government, they can only take the copy of this, download this model standing order, respectively to whichever sector they belong, and place before the certifying officer to certify it by putting the seal of the department or the industry, and the certifying officer will be able to certify those standing orders, and they will come into operation. And if at all, if any modifications are to be made in the long run, in time to come, there is a schedule annexed to the IR code, what type of modifications that are to be made, that the points that are mentioned, the items that are mentioned in the schedule will be taken up for modifying the standing orders, and signature of the trade unions, the management could be obtained, and the signature of the certifying officers also could be obtained. So this is all for the industrial establishments undertaking where there are 300 workers. But then, what about if any standing orders were already there in practice in certain establishments and undertakings where there were less than 300 workers? Because there was no uniformity under the ID Act, under the Industrial Employment Standing Orders Act. Some factories, some industries used to have 250, 100, 300, 200, like that. There was no uniformity. So the new IR code has brought in some sort of uniformity by fixing the threshold of workers up to 300 and more. And they have provided the model standing orders also. No much more difficulty. Then, if at all such industrial establishment less than 300 already had standing orders, what they could do is they could only take it to the certifying officers and convincing that we were in practice and we wanted to adopt these standing orders for our industrial establishment and undertakings. So the certifying officers certifies, then the standing orders will come into operation. So these are very interesting provisions that are there in the industrial standing orders under the new IR code. So definitely I believe that this will in a way help in ease of doing business, because less than 300 workers also we can have the old standing orders continued. And in case if at all there if a new establishment had started with 250 workers, so my suggestion is that, my advice is that they can formulate their own standing orders, but they are subject to be questionable before the courts, provided they are contrary to the model standing orders. They could be questionable before the court, but then you have the liberty to frame your own rules for issuing notice, conducting inquiries, for misconduct, all that. The only thing is that you should convince the certifying officer and get it certified. So there are all possible ways for you to have standing orders and see that the relations are very smooth, harmonious, cordial, and friendly, both to promote business and for balance, think the workers' rights. Now I come to a very important conceptual analysis on the concept of grievance redressal machinery, which is a very new concept that is added in the new IR code. A very democratic concept, I feel. Wherever in any industrial establishments undertaking, there are 20 or more workers, they have to set up a grievance redressal committee, and the grievance redressal committee can, there is a rider here, take up such type of individual disputes. Please bear in mind, mark this word, individual dispute, which arose less than 1 year. So if the dispute has arisen today, you have got 1 year limitation period to bring it before the grievance redressal committee. You cannot bring old disputes which existed. The limitation period is that 1 year. Any dispute which was there between the employer and the workers, Such type of dispute could be brought before the grievance redressal committee, and the grievance redressal committee will have such many number of workers, and they are given prominence for women workers. There has to be women workers too in the committee. And see the interesting point. The interesting point is that no sooner a complaint is registered or filed, they will give a number, GRC number, GR complaint number 1 of dash year, and that complaint has to be resolved within a period of 30 days from the date of filing the complaint. In case if the GRC does not resolve a dispute within 30 days, then such a dispute will automatically go before the conciliation officer. So this is the beautiful uh, method of resolving individual disputes, where you need not have exposure of any support of any union. Individual disputes could be directly be taken up by the GRC and resolve it within 30 days, failing which the dispute will automatically go to the conciliation officer. So this is a very, very interesting provision for ease of business. If the disputes are resolved easily, early, less expensive way, then the relations will be very good and friendly. The production, distribution, supply of goods will be a little bit faster. Disputes cannot remain pending. You might have heard about one interesting case. I don't remember the name of the case. It just by default, the workman filed a dispute in the civil court. The matter came to the labor court, it came to the high court, it came to the Supreme Court. They said civil court have no jurisdiction. High court said no, it has got jurisdiction. So like that, has no jurisdiction passed on to the Supreme Court, and finally the Supreme Court had to decide the civil court had no jurisdiction to entertain the dispute that could be adjudicated by the labor court. So by this time, 36 years had passed off. And you might have heard about Shanmunath Mukherjee case also. By that time, he received the compensation from the government. He passed away. Because the dispute that could be that took time to resolve was so enormous time. So therefore, keeping these points in mind, the lawmakers have made it possible to some extent to resolve the dispute in a very fast way. Now, I'll be coming to another set of another conceptual analysis of investigating and settlement of disputes under the new IR code. So, ladies and gentlemen, I told you, I wanted to tell you, and you are all aware, there were 6 forums for investigation and settlement of industrial disputes. Works Committee, Conciliation, Board of Conciliation, Court of Inquiry, Labour Court, Industrial Tribunal, National Tribunal. Of course, Works Committee we don't consider. But then, out of 6, now they are reduced to 3. Then the Conciliation, Industrial Tribunal, they abolished the labour courts now, the National Tribunal. So they wanted less adjudicating, investigating machinery for early and easy settlement of industrial disputes. So therefore, If I take up the concept of conciliation, so there is a conciliation officer appointed by the appropriate government, not below the rank of normally assistant labor commissioner. And whenever there is a industrial dispute likely to arise or apprehend, the conciliation officer will intervene to settle the dispute amicably by conciliating between the parties to the dispute. And one change that the IR code has made for faster investigation settlement of dispute is that they have introduced a time period for the rules have introduced a time period for resolving the dispute. Within 45 days, the conciliation officer has to resolve the dispute. Like how 30 days time is prescribed for the GRC, Grievance Redressal Committee, that in the same way 45 days time period is prescribed for the conciliation officer, which is a welcoming change in the new IR code for settling the dispute. And the copy of the same will be sent to the appropriate government and the labor office. But the sad thing is that again there are no qualifications prescribed for conciliation officers. Of course, the conciliation officer is from the government. There are no proper measures for training at all. They are well trained. They will settle the disputes in a very faster way. But this facility of training is not there under the Act. Many researchers wanted a qualified trained conciliators. But then it couldn't happen in the new IR code. But then the 45 limit period is prescribed for resolving the dispute. Failing which the matter will go to the industrial tribunal. So the industrial tribunal is a very interesting forum for investigation and settlement of industrial disputes. Earlier, there used to be one judge in the industrial tribunal. Now, it is a double bench. There will be two persons seated in the industrial tribunal. One is from the judicial side, another is from the administrative side, who has got well-versed experience about labor matters. And the double bench seated tribunal will decide 5 types of industrial disputes, and all other disputes will be decided by this single member, the judicial officer. So, 2-member industrial tribunal will decide disputes such as interpretation of standing orders, dispute arising out of discharge, dismissal, or termination, retrenchment, illegality of strikes or otherwise. And most importantly, one very interesting change they have made, dear learned friends, is that the trade union disputes will no longer go to the civil courts for determination. The jurisdiction of the civil courts is totally barred upon the trade unions, and the jurisdiction is now vested in the industrial tribunals. So here, the very interesting bright point is that because civil courts, they have their own set of litigations of different kinds, and to avoid this additional burden, they have given the jurisdiction to the industrial tribunal. Barring these type of 5 disputes, all the disputes will be adjudicated, determined by a single member. But one another important change they have introduced is that they cannot bring disputes which are very old and old and old, kept in storage. Disputes that arise within a period of 2 years. The limitation period is 2 years. Only such type of disputes within 2 years could be brought before the industrial tribunal. No other disputes could be the subject matter of jurisdiction for the industrial tribunal. It's a very good provision for doing ease of business as well as for balancing workers' rights to get early, less expensive justice. And there are national tribunals, and we have voluntary arbitration also. So, this is how I can convincingly say that the concept of investigation settlement of industrial disputes with the three forum machinery will go in a long way to promote ease of doing business and also to balance workers' rights. Now coming to the very interesting area of strikes and lockout. The next concept of mine is strikes and lockout. Very interesting, friends. In the beginning itself, I have told, see, no workers will join any industry or factory undertaking or concern to disturb industrial peace, to misbehave with employers, to cause interruption in distribution, production, and supply of goods and services. No worker will join, no matter whatever he is paid. He will join to make his living easily, whatever he gets. In a very innocent way, he joins. But then we have a constitutional right to form union. There are certain leaders who come forward to form unions. They form the unions. And once if they form the unions, they wanted to show their power. So the power of strike is a tool for the workers. Equally, balancingly, the law has also provided the power, the tool power of lockout upon to the employers also. So how to balance these two dangerous tools? Because strikes and lockouts do confer rights, do provide justice in different ways, protect workers' rights, but at the same time, the atmosphere in the industry should not be disturbed. So, what has to be done here? You know, in our Indian judicial setup, the very first case which arose whether right to strike is a fundamental right or not, I believe most of your learned teachers know it. All India Bank Employees Association versus National Industrial Tribunal, 1962. I am of the view that for the first time, without any Right to Information Act, the workers had demanded the balance sheet of the management to ascertain how much profit the management is going to derive from the work or labor of the workers. They wanted to know the balance sheet. The management said, no, we can't disclose and give the balance sheet to you. workers are members of the trade union. We don't want it. Then they went on strike. All that way the matter went to Supreme Court. So what happened? The Supreme Court said there is no fundamental right to strike. Followed by this, Commissioner Prasad was the state of Bihar, no fundamental right to strike for workers. Followed by this, the industrial, the uh, state of Tamil Nadu versus Rangarajan, the government employees, neither they have fundamental, moral, or equitable right to go on strike. The matter is still pending for review, if I am right. Otherwise, I will stand corrected if it has been resolved. I will stand corrected. To best of my knowledge, the matter is still for review before the Honorable Supreme Court of India. So, we have not till today uh, ratified the two important ILO conventions on collective bargaining, right to organize and collective bargaining convention, freedom of association and right to collective bargaining convention. We have protection of right to organize. We have not ratified, but for constitution is the ground rule for all of us to form unions. We do form, but freedom is there to speak, to demonstrate, to organize, but there is no strike for you to do as a matter of fundamental right. And it is not a statutory right also if we stricto sensu interpret the provisions of the ID Act, IR code by referring to the definition of strike. So one change they have made here, that is earlier 50 a mass leave with 50 and more workers were going on strike, and there was no remedy for the court to decide whether it is a strike or not. The court should to decide is not a strike because there is no provision here. So now they have added mass leave with more than 50 members. If they go on strike, that is also amounting to strike. So here again the word person is used while defining a term strike. So this is how the concept of strike is looked at. And the new IR code, to most of the researchers, they have come to the conclusion or they are of the apprehension that the new IR code is imposing enormous restrictions upon strikes. The significant change that the new IR code has made is that earlier the strikes were divided into two sectors: public utility services and non-public utility services. So, utility, if any notice is given by the trade union to go on strike in public utility services, am I audible? Am I audible, man?
Yes, sir, you are audible.
Because my earphone is a little bit. I am audible clearly.
Yes, sir, you are audible.
Yeah. So the significant change is that whenever the trade union want to go strike in public utility services, there was a compulsory conciliation. The conciliation officer compulsorily had to intervene immediately for resolving the dispute. Now that is done away with in the new IR code. They have discontinued with classifying the public utility services and non-public utility services for the purpose of attracting restrictions on strike. In any industry, if at all the trade unions want to go on strike, 14 days prior notice is to be given. It says that no persons can go on strike in any industry against the breach of contract, no strike could be organized before giving 60 days of notice to the appropriate government. And from 14 days of giving such notice, no strike could be organized. And further, if any date is mentioned in the notice, the up to such a date there should not be a strike. There are a lot of breaks and strikes. So therefore, the researchers are of the apprehension that they have further made very difficult for organizing strikes under the new IR code, only to help the employers for promoting their business, but without balancing any rights of the workers. That is the apprehension. But then, to some extent, I will I will just uh, reduce the criticism to some extent. See, dear friends, why that period 60 days is mentioned before going on strike? Can I have any answer from you all? Why 60 days period is mentioned? What may be the reason? Earlier, the 60 days period was not there under the old IR code, ID Act. Now, 60 days period is mentioned here. 2 months prior notice has to be given. If at all any union want to go on strike in any industry. Why? Just please, within some time, we can think over. Yes, sir. Yeah, please.
To provide an opportunity to the employer for making some alternate arrangements, sir. So when the strike is
Of course. See,
called.
alternative arrangements could be made in 1.5 month also, within 1 month also. Why 60 days period is mentioned? See, my dear learned teachers and friends, the 60 days period is mentioned with a simple reason. See, a strike, when we look at the provisions for illegal strikes and illegal lockouts, see, whenever we are going on strike, 7 days before the 7 days after the commencement of the conciliation, and 45 days after the conclusion of the conciliation proceedings, we cannot go on strikes. So these 45 days plus the remaining 14 days which is there, where you cannot go on strike, will amount to 45 plus 14, roughly around 60 days, which is 2 months. So for that reason, they have added this word 60 days in the notice period to facilitate during the pendency of conciliation proceedings and the conclusion of that proceedings, 45 days. Because the time limit is now prescribed for the conciliation officer to investigate and settle the dispute within a period of 45 days. Otherwise, to directly go to the tribunal. So for that reason, dear friends, they have added, I believe, 60 days prior notice, not to restrict the workers to go on strike. It's a facilitating, enabling provision, not to continue and fall into the trap of illegality of strike. So a illegal strike out of illegal lockout is illegal. A illegal lockout out of illegal strike is also illegal. Apart from this, there are these provisions. So also, we cannot go on strike when the proceedings are pending for the industrial tribunal and 2 months after the conclusion of such proceedings. So these are some of the very interesting provisions which are there for strike. But then we are in a very new era now. That is, we are in a era of development. Vikas, I'll come back to that. What is that Vikas? And today, you know, it is the last day of the Mahatma Gandhi National Rural Employment Guarantee Act. The new act, Viksit Bharat Rural Employment Scheme, that is VB Ramji Guarantee Act, will come into operational from tomorrow. I'll come to that point later on. But then see, here the object of the lawmakers in the IR code, no doubt, maybe to restrict strikes, but at the same time, they wanted to have ease of doing business without interruption for production, distribution, supply of goods and services, which is very important for making a developed country like ours. So, lastly, but not the least, before I will now deliberate upon a new concept. This already existed concept, that is the concept of layoff, retrenchment, and closure under the IR. Am I in time, my dear coordinator, sir? Am I in time?
Yes, sir. Yes, sir.
Time ಎಷ್ಟಾಯ್ತು ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
Yes, sir. Yes, sir. You can continue.
ಟೈಮ್ ಇದೆಯಲ್ಲ, ನನಗೆ 1.5 hour ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ.
Sir, 7:17 now. You can take another 10 minutes to conclude, sir.
Yeah, that's what I should not
Yes.
waste, because I should have some time to interact also, if at all.
Yes, sir. Yes, sir. You can take 5 minutes to conclude.
Yeah.
And the remaining 10 minutes can be used for question and answer.
Sure.
Yes,
So,
sir.
now I would like to just come to the very new, already existed concept, retrenchment. Again, here there is a criticism by many researchers that by increasing the threshold of 300 workers for retrenchment and closure is not justified. It is pro-employer provision for promoting and doing ease of business. Of course, to some extent it may be true. But then, the only distinction here is regarding the threshold of workers. There is no any defeat of providing non-employment benefits, that is the benefit in form of compensation for layoff, retrenchment, and closure. Here, if at all we have 300 workers or more, then 3 months prior notice has to be given. If at all there are less than 300 workers, 1 month prior notice, along with 1 month leave with wages. The point to be noted here is that just 1 month leave with wages is not enough. They have to annex the check of 1 month wages to the notice and give to the employer, give to the retrenched workers. This change they have made it in the rules now. They cannot prolong the 1 month wages for them. And secondly, one interesting change they have made is that for every completed year of continuous service, they have to provide 15 days wages as a matter of treatment compensation. So there in the old ID Act also, it continues for the in the IR code also. But then the one change is that 15 days wages should be given to reskilling fund. Reskilling fund. For when we retrench workers less than 300, 15 days wages are to be deposited with the government, and that fund will be considered as a reskilling fund. It will be utilized for reskilling and training of the workers in case if they are reinstated back to work if needed. So that new provision of reskilling is there, and more than 300 notice has to be given prior to 3 months. And many of the researchers feel that the government will very easily sanction accord for closing down or for retrenching the workers. But practically, for some, it is not so like that. It will be very tough time for them to get permission from the government, because the government also will be very appropriate. Government also be very careful to see that if at all if it is closed, if at all if the workers are entrenched, will it create law and order problem? Will it create problem of livelihood? All these matters are there to be considered before the appropriate government, and accordingly, it is not so easy to get permission for closing down or retrenching the workers. And for layoff compensation, wherever there are less than 50 workers, most of the provisions are more or less same, but they're disqualified for having layoff compensation, provided if it does not present before uh, the establishment daily for any work. If it doesn't himself present, if he remains absent, no compensation. And if he refuse any alternative employment in any industry, having same skill, with the same skill that he could continue his work, provided that industry is within a radius of 5 kilometers. It was 5 kilometers in the earlier act of the, that is reduced to uh, 1 kilometer now. Within 1 kilometer radius, any employer provides any employment with same skill that he had possessed before layoff, and he could continue with that employment, will be disqualified for layoff compensation. And for 45 days, if there is any written agreement, up to 45 days is eligible. Above 45 days is not entitled for any compensation in case if he is having any written agreement with the employer. These are some of the interesting provisions that have been introduced under the provisions relating to layoff, retrenchment, and closure. And again, I am of the apprehension that they do promote ease of business, and at the same time, they, in one or the other way, they try to balance the working, or balance the rights of the workers. Let us be very positive and optimistic, so that you will. I am of the optimistic opinion. The IR code in the time to come will be very useful for the workers also, will be useful for the employers also. Okay. Now the last concept which I wanted to touch is the IR code defines for the first time a new category of employment called as the fixed term employment. So fixed term employment is there, and you know, again, if any employer enters into a contract of employment for any specified period, uh, for engaging a fixed term worker, he can do so. And if he does, the fixed term employment fixed term worker will be entitled for all the statutory benefits that are accruable available for the permanent workers. Only change they have made is that if the fixed time worker is employed for 1 year, he is eligible for gratuity. Because normally the gratuity period for eligibility is 5 years, but for the fixed time workers, if he is employed for 1 year, then he will be eligible for gratuity. If he is not employed for 1 year, uh, then he may also lose the retrenchment layoff, retrenchment closure compensation, because the condition precedent for retrenchment is that 1 year of continuous service should be there. But the fixed term employment is very good, so that the workers who are appointed under this category by the employer will be having some sort of affinity with love and affection that they are being given all the status of permanent workers in the matter of statutory benefits, and their output and their work output also will be good. Is the apprehension of many researchers, but then we have to wait and see how these type of workers could be engaged in different sectors. So these are all the provisions which I felt I should inform to my learned teacher friends in this very important faculty development program. I am the last batsman. I don't know how much I have scored in enlarging your knowledge and making you a more developed, knowledgeable teacher. I am not. Uh, uh, I don't know, but then to best of my ability and knowledge, I have done so. But then before just concluding, I wanted to make some passing references. Dear friends, see the pre-codification period and the post-codification period. See, the very important question for research is that we should have very reliable data on labor matters, especially. That is the Bureau of Labor Statistics, Chandigarh, the annual labor law reporters released by the Ministry of Labor and Employment, and the very important report, the periodical labor survey reports received, released now and then. Every year they will be releasing, and whenever it is urgent, they will release the reports. These reports are very authenticated reports. And dear friends, when we look at the data out of these two, out of these survey reports, see, we are living in a country where there is a very strong narrative built up of ease of everything, ease of doing business, ease of living, ease of writing examinations, ease of getting marks cards, ease of doing that, ease of doing this, all ease. But how far, I don't know how far we have a good climate for ease of breathing. I don't know that. So here, when you look at the data, you know, growth, the data which is our growth, GDP growth up to 6.7% or whatsoever, I feel that it may not be so accurate because the data which is provided by the World Bank, Asian Development Bank, IMF are not reliable data for determining the growth of our country. So the growth of our country depends upon the manufacturing sector, the service sector, and the IT sectors and many other sectors. So when we look at the pre-codification period, there were more number of unorganized workers outside the coverage of labor law. The post-codification period, which is going to commence, I am of the apprehension that that coverage is going to increase to some extent, not to a larger extent. Still, the bulk of the unorganized workforce will be outside the coverage of the labor laws. What to do for those type of unorganized workers? What policies we have? I am not so fully convinced about a sound policy for these type of unorganized workers. When we got independence, when we compare to the southeastern countries like Singapore, Taiwan, China, Korea, Japan, you know how they could grow faster and faster, and how we could not grow so faster and faster. If at all we want to have a developed country by 1947, what our Honorable Prime Minister says, I believe we should have at least per capita income of $14,000 per capita income is required. Now, what is the per capita income? And what is the status of the manufacturing sector? When you look at the data, the manufacturing sector is not so doing well. It is very stable. It's very, very stable. And so also the services sector also is not so encouraging. It is also more or less stable. So by this, what happens is that the small and micro medium enterprises, their problems are to be addressed. See, after 2014, around 75,000 SMEs have been closed. So, how to revive them? So, when we adopted the liberalization, privatization, and globalization, the then Prime Minister, Mr. Narasimha Rao, had to introduce the National Renewal Fund for renewing the industry that was going to be closed due to contractualization, casualization, and other ways. So to renew them, we had kept some renewal fund for renewing the industry to restart. But then I am an optimistic. So all of us will wish that our country too should be a developed country and not so faster, but slow and steady. In this regard, I conclude with a statement given by Mr. Uh, uh, Mr. What is his name? David Scorcher. What he says that he's an American politician. He says that, see, but all it has to be a just development, national or global. Such a development should be inclusive and should increase the capabilities of all. Development means it should be an even development. Increased growth means it should be inclusive growth. Even development with inclusive growth will make our economy very sound and make our industrial relations very smooth, friendly, peaceful, cordial, harmonious. And by this, I conclude my presentation and I'll keep this house open for asking any questions which it comes to your mind, and I'll be happy to best of my knowledge and ability to address those questions. But bear in mind, dear learned teachers, see, we were all writing answers to the questions in these examinations. Now we have to start a new thinking, a new idea, how to frame questions. Framing questions, framing appropriate questions for getting very appropriate answer is a great challenge. If I ask anybody to question, they'll feel very difficult to question. Please, I have, this is my apprehension. Until we are acquainted with knowledge, we cannot raise questions. If at all we are acquainted with knowledge, then there are some doubts, we can clarify the doubts by raising such questions. So the house is open for question. With the permission of the Honorable Principal and Coordinator, I seek their approval to keep this house for questions.
Thank you, sir. Thank you for your nice presentation. It's indeed a lucid presentation on the topic. Now, this presentation is open for discussion. And Vijay, you can take some questions which are posted in the chat box, please.
Yes, sir. There are some questions in the chat box. Vijay has a question that penalties like imprisonment for employer offences have been largely removed or made compoundable, whereas penalties and fines for illegal strike by employees remain strict and have been enhanced. Is it not a pro-employer?
I got the question. Very beautiful question.
Yes,
I don't know when I suppose Mr. Vijay you posed it. Huh?
yes,
don't
sir.
know.
He is from Belgaum.
Acha.
Yes, sir.
So
Gadad,
very
Gadad.
beautiful question. I wanted to touch upon this,
Yes.
but due to paucity of time, couldn't. See, a very interesting change that the IR code has made, dear learned friends, is that a fine from 20,000 to, I believe, some 20 lakhs, if I'm right, I'll stand corrected. Fine is proposed there for any violation of the provisions of the code. And there is a provision for compounding of offences, in the sense that if the employers concede to the violation, agrees to the violation, he can pay 50% of the fine imposed upon them, and he can get away with the remaining penalty. So this change they have made, but then the reason why they have increased the fine and they have limit from 20,000 to 5 lakhs is that, see, where earlier ID Act had very less amount of fines and penalties. So the employer would have not bothered to pay that fine and come out of the violation. But now these fines are increased so that it is an alarm for the employers not to fall into the net of violations. But then again, there is a very testing period for all of us to introspect and wait and see, wait and watch how far the bureaucrats will react to this changed scenario of increased fines and penalties. If there is corruption involved, then the object of increasing the fines and penalties will be definitely defeated. This is my answer.
Yes,
Go
sir.
for next question, please.
Netra madam has a question. Whether in the matter of compensation, both workman and employee are come under the purview of same or not?
No, 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 no. I have made it very clear. The worker is used for all the benefits under the IR code, except for two categories of workers. I told you, the newspaper employees, journalist newspaper employees, and the sales promotion employees. There, the word employee is used for the purpose of their any benefits. But otherwise, the word worker is dominating in most of the provinces of the IR code.
Yes, sir. There is another question from Jaykumar KS. What are the important emerging challenges facing industrial relations, new Labor Code 2020 today compared to the old ID Act?
I have already added in my presentations. So the new challenges are there is that So it is a challenge for all of us to promote ease of business and also to balance workers' rights. Without business, the employer cannot share profits, be it be gratuity or be it be bonus, without or employees compensation, whatsoever benefits are there. So these could be possible if there is a balancing of workers' rights and also their ease of doing business. But the second challenge is that we have to develop R&D Dear friends, what is the amount of budgetary amount which we are spending on education? What was the target? 6% of the GDP should be spent on education. How much we are spending? 3.8% of the GDP. Education, some writer writes in South Africa, if a nation has to be destroyed, destroy the education system. The nation will automatically be destroyed without any war or weapons. So our education system should be very sound. For the reason that there should be enormous scope for research and development. R&D is not so progressive to best of my knowledge and ability. We are doing research, PhD, degrees, awarding for the purpose of awarding, not for really doing some valuable research. We have not, because somehow we have to get degree, somehow we have to get promotion. Okay, this is not a critical point from my side. We have to get our degrees. These are our right, no matter. But at the same time, the research should be very, very, very useful for the progress of the country, for the progress of the employer, for the progress of the workers and the employees. So, education is not so well looked at or looked upon by the governments in the past and the governments in the present also. Secondly, the third challenge is that health. What is the GDP portion of GDP we are spending upon health? Very, very, very less. A sound body in a sound mind, with a sound mind, a healthy body with a good output of work. How can we have it? So this attention upon health, of course, in the Code on Occupational Health and Safety, there is a provision somehow for annual health checkup for all the workers. All the workers annual health checkup immediately. But then we have to see how those health checkups will be conducted, what are the different health checkups they are going to make and all. Checking is easy, remedy is difficult. We have to sponsor for the remedies, right? And I told you, the manufacturing sector, service sectors are to be improved, the exports are to be increased, and most importantly, the challenge is that regarding the foreign direct investment, learned teacher friends, the foreign direct investment, when you look at the data, that is decreasing, not so progressive. And the foreign portfolio investment is also very, very not so sound. So if at all we don't have these foreign direct investment, foreign portfolio investment, then it will be very difficult for us to have the growth what we wanted to achieve it by 1947. If all we want to be a developed country, these areas are to be looked at with very serious way, and there should be a very policy which is very helpful for promoting these type of areas to progress well. These are some of the challenges which I feel.
Yes, sir. Thank you, sir. Before going to wind up, I want to show you a book written by one of our participants here, Mr. Vishak Voti.
Vaishak.
Yes, Vishak Voti. I received book in the morning. This book written by him on labor reforms, a catalyst for Vikshit Bharat 2047. Is a presently working as Assistant Labor Commissioner at Andaman and Nicobar Administration, had written a wonderful book which throw light on how these labor reforms, a catalyst for Viksit Bharat 2047. He discussed it ranging from the contextual and foundations overview, and also he has discussed something about the constitutional framework, the legislation's pre-independence, and up to ILO perspective, etc., etc., and discussing something about code on wages. And what impresses me a lot is views on labor reforms and foreign direct investment. This book is available for sale. It is published in the month of March 2026, published by Blue Rose One, New Delhi and London. It is one of the interesting book on this new labor code, and I recommend this book to each and every one of my colleagues. And also, it is a wonderful book to keep in the library to abreast with the latest development on this new labor code. And thank you, sir, Vishak Oti, for joining us from the beginning and encouraging us. He is the only a bureaucrat, perhaps from the beginning, joined our FDP program.
I'm very happy that I did not get any question from a very experienced bureaucrat. If he had put me into trouble, he would have put number of questions.
No, sir, he has simplified everything here. And the beauty of this book is from the small and medium industries up to the challenges faced by the society, particularly on AI and its response by the labor code and etc., etc. Such things are also new thing. And yes, I read only 2 chapters what he has written, particularly on future of work and labor policy. The interesting aspect here is automation, AI, and job transformation. Yes, rightly identified how India is facing the challenges in adjusting to the new situation, more particularly pressurized by the foreign direct investment. Sir, thank you very much for your lucid presentation in this book, and I hope it will become one of the torch bearer. I mean, it is one of the resource for all the libraries in a law library particularly, and it would guide all the teachers to understand the policy behind adopting the new labor code. Thank you, Vishak sir.
Thank you, sir. Thank you. Thank you. Thank you very much.
Okay, Vijay.
Yes, sir. Yes, sir.
Sumitra.
Yes, sir.
Dr. Sumitra.
Yeah,
Yes,
request
just a minute.
Dr. Sumitra, our Assistant Professor Vivekananda College of Bangalore.
Before that,
Thanks.
Yes, sir. Yes, I'll make an
Vijay, I
announcement.
want to
Yes,
know
sir.
before that the opinion of the participants. In
Okay,
case
sir.
of any mistakes from our side, it is it is an opportunity for us to improve upon, at least to minimize that inconvenience caused to the participants in this respect. Please
Dear
unmute yourself and give your opinion, please.
Dear participants, I request some of you to express your opinion. That would be helpful for us to plan in the future. Plan better, rather. It would be nice if somebody could come online, unmute yourself and speak. And it would be great if you can switch on your camera so that we can take a picture.
Hello.
Anybody interested?
Yes. Madam Ramya CJ.
Somebody.
Yes.
Yes.
Good evening, everyone.
Good evening.
It was a pleasure to attend the session, 7-day faculty development program. The resource persons, whoever you choose, is quite knowledgeable, and it was very informative session. One small suggestion is that I was not able to attend the first session because there was no communication which was put across through mail. So I was not added. So I had to call up the contact person and made me add into the group. So if that has been, no, that's the only thing which I could feel. Otherwise, the session was quite informative and very well the timing, that which I will always appreciate, the timing you started it, its punctuality was always done. So thank you so much. I'm happy to be a part of. And by the way, I'm from Havnu College, working as an assistant professor. Thank you, everyone. Thank you, the organizing committee and all the resource persons.
Thank you, madam. Sorry for the inconvenience caused to you.
No, it is.
Yes.
I mean, when the program is being arranged, I know there will be some errors. I mean, it's not a. I mean, just point out something. That's all. It's not a big mistake.
Okay, madam. It is taken in. Right.
Okay, thank you.
Anybody?
Sir, good evening, sir.
Jaikumar, sir, please.
Yeah. So, respected faculties, so all 7 days FDP program, first I am thank you for Vivekananda College of Law, entire team. Because a special aspect regarding to the new labor codes 2020, but not I teach by the labor law subject, but only for the personal law. Madam, audible?
Yes.
Yeah.
Yes,
So, once again, sir, thank you for all entire team is conducted by the wonderful FDP program, especially in the new labor code 2020. So various aspects in the resource person is a various thought, provocation, and challenges. What are the important of the grievance redressal and mechanism, etc., etc. It's a very wonderful workshop or in the FDP program. It's a useful for especially for the labor law teachers. Once again, thank you for entire Vivekananda College of Law. Thank you, sir.
Thank you, Jaikumar. Anybody, please? Okay, thank you. Thank you, Nandal, for your kind cooperation and joining us, having faith in us. Vijay, sir, I think you have unmuted.
Vijay, sir, is traveling back home.
Thank you very much for your Dashrath, sir. I'm very much happy by your informative and it was so learning.
Yes.
Really, it is appreciable and we compliment for your informative session, sir. And we also thank Dr. Kempegowda, sir, for organizing such a wonderful program on this new labor code. Because most of the teachers we taught the labor law, but since it was very new, it required some research on that, and it's very wonderful for this. I thank Bhuneshwari madam and Vijay sir also for having such a coordination for organizing this program. Thank you, sir. Thank you so much. And even resource persons are very, very good, especially Dashrath sir and Baba Gowda and even
Sandeep Desai,
sir.
Yes.
It was a wonderful session, sir. Thank you so much, sir, and we look forward for some other area. Thank you, sir. Thank you so much.
Definitely, sir. Thank you very much. We are committed to organize much more FDP programs. Of course, it is my last program as principal. My colleagues will be there in future and they will take care of it. Thank you.
You are a jurist, sir.
Thank you. Right, sir. Anybody? Okay. Yes, I thank each one of you for your support and over to you, Sitra, for.
Vivekananda, sir.
Yeah, yes, sir. Subhash.
Yes, sir. Happy to meet you.
Thank you. It's my pleasure. Yes.
I have joined from Kerala. Now I am in Kerala now. So principal Ilahi Law College Muatuvida. So I thank you. You have chosen very nice persons as resource persons.
Yes.
And you have chosen a subject which is of very relevant, contemporary relevance. So really I enjoyed. I got a very, very good information. And I thank you. And I take this opportunity to thank Pratibha ma'am. She invited me to join your program. So very much. I thank you. Thank you very much.
Thank you. Thank you, Subhash ji.
Okay. Thank you.
Right. Yeah, Sumitra,
Yes, sir.
over to you, please.
Yes, sir. Good evening, respected resource person for the day, Professor Dr. N. Dashrath, former professor, University Law College and Department of Postgraduate Studies in Law, Bangalore University, Bangalore, respected principal, dear participants, my dear colleagues, it's my privilege to propose vote of thanks and bring the curtains down on this 10th 7-day faculty development program on new labor codes. At the outset, I express my gratitude to Professor Dr. N. Dashrath sir, who made a lucid presentation on the topic interplay between ease of doing business and balancing workers' rights in the light of labor code on industrial relations and analysis. Thank you, sir, for disseminating your expert knowledge in the field of labor law. I thank our management, Janta Education Society, which extends its unwavering support to all our academic endeavors. I express my heartfelt thanks to Madam Sapnayan, our Governing Council Chairperson, for her timely assistance. I express my gratitude to all the resource persons who shared their wealth of knowledge during these 7 days and sowed the seeds of wisdom and made this faculty development program an ongoing learning experience. I would like to place on record the untiring efforts and perseverance of our principal, Professor Dr. K.P. Kempegoda sir, in conceptualizing this academic exercise and making it a reality for all of us. Neither he will be at peace, nor he allows us to be in peace till he accomplishes his academic plans. He is a taskmaster. Thank you very much, sir. I thank the faculty coordinator of this FDP, Dr. Vijay A.N., assistant professor, who impeccably coordinated this FDP without any glitches, though it is his maiden FDP as a coordinator. Thank you, sir. I thank our IQAC coordinator, Dr. Bhuvneshwari S. Kolaki, assistant professor, who is the epicenter of all our activities, for her painstaking efforts to commence the meeting every day on dot and sitting through the meeting and ending the meeting for all of us. Thank you, madam. I cannot ignore the support of our technical team headed by Srimati Nirmala P. Hegde, assistant professor. Thank you, madam. She is our emergency engineer. I thank all the participants who have lent their continuous support, because of which we are able to complete this 10th faculty development program. I would like to bring it to the knowledge of everyone that we enjoy the patronage of repeat participants who join us in academic exercises year after year. Thank you, dear participants, for reposing trust in us and helping us organize FDP successively successful. I thank my colleagues for lending their timely support in seeing this event through. As most of the participants are aware, we conclude every semester by hosting an academic exercise like workshops, seminars, and FDPs. The conclusion of this FDP marks the conclusion of the semester as well. Finally, I thank everyone who have been with us in this academic journey. We finally wind up this FDP on new labor codes with a sense of complacency that we have learned something new. All the recorded sessions are available on YouTube. Kindly feel free to access and share the same with your students and other faculty members if there need be. I, Sumitra, are signing off with a hope to receive the same kind of support and patronage in days to come. Thank you all. Take good care of yourselves and indulge in self-love. Thank you, one and all.
Thank you. Thank you, Professor Dashrath sir.
Thank you, sir, for your gesture
Very
in
much
inviting me.
Sumitra madam,
Yes,
make
ma'am.
another announcement that we have shared the participants list in the group.
You can.
So as soon as possible, they have to verify their records so that we can issue the e-certificates at the earliest.
Yeah, this is in continuation of the announcement made by our IQAC coordinator, Dr. Bhuvneshwari S. Kolaki. This is to bring to the knowledge of all participants to kindly fill up 2 feedback forms and see that whatever the particulars that you furnish are correct, because whatever the particulars that you have given, you are going to get the e-certificates with the same details. So kindly look at your particulars, and if if you want any changes to be made, kindly let us know. We will do the same and we will provide the certificates at the earliest. And thank you one and all. Thank you once again.
Thank you, sir. God
Thank
bless
you,
you all.
Professor.
Thank you, Dasharath
Thank you.
sir.
Thank you. God bless you all.
Okay.
Thank you. Thank you
Thank
all
you.
the participants for joining us. So shall I end the meeting?
Please.
Yes.
Bhuvaneshwari madam,
Yes,
if we
madam.
can ask the participants to switch on, the camera,
na, madam.
turn on the camera. If we can take a screenshot.
There are very few participants left out, madam. There are
No,
only
whoever is there,
27.
if we can take a
So
screenshot.
participants, whoever is available, and if you are in a convenient mode to switch on your camera, please do the needful so that we can take a group photo.
Madam, if we don't have many.
Yeah, wait for a while, madam. They are switching on the camera. We'll wait for a while.
Okay. Our participant, Mr. Vijay, is looking very good in a bus. So sweet of him to turn on the camera.
He's struggling to.
Yeah, so sweet of him.
I travel usually around 6 to 8, madam, daily, every day. It was
Yes.
at 6 o'clock, it was very much convenient for me to join this program.
Yes, sir.
Yeah, participants, I'm taking the group photo. Please look at your cameras. Thank you so much. Thank you for joining us and for your encouragement and support. Thank you so much. Sir, shall I end the session?
Please, ma'am.
Thank you, sir.